Welcome to This Week in Family Law, the go-to podcast for busy Australian family lawyers to stay updated without the overwhelm. I'm Jenna Downey, family lawyer and managing director at Leap Family Law. Today, co-hosting the episode with me is family lawyer at Leap, Brendan Chu. How are you?
I'm good. Thanks, Jenna. Thank you for having me. How are you?
Thank you for being on the episode. I'm very well. Thank you. Before we get into the first What's Up segment of the podcast, I wanted to just make a few comments, and it's mainly to say that since we dropped episode 1 and also our introductory episode, we've been pleasantly surprised by the number of people who have been actually listening to the podcast. I just wanted to thank those listeners, and also the number of emails that we've received and the engagement we've received from those listeners asking questions and making comments has been really nice to receive. So please continue to send any questions, comments you have through to us. We also welcome any feedback that you've got. This is obviously a new podcast. We want to make it as relevant and valuable as possible to you, so please don't hesitate to provide that feedback. Our email address is familylawpodcast@leap.com.au. In terms of why we wanted to start this podcast in the first place, I'm sure many of you are like me and felt quite overwhelmed and burdened by the number of updated emails I would receive on a daily basis into my inbox. And I would often flag those emails with the very good intention to go back and read them, and I just never had the time. So the idea is that we will do the trawling through those emails for you and bring to you those important updates that we think are relevant to share with you. And we want to keep these podcast episodes very bite-sized, so up to 25 minutes to give you time to actually listen to them and also digest the information easily. We drop the episodes on a Monday with the intention that on your way to work you can listen to an episode quickly, and then by the time you walk into the office, you feel confident that you've got the information that you need to for the week to be updated in family law. Now, let's get into segment 1. What's up, Brendan?
Thanks, Jenna. So some good and positive updates this week. On the 26th of January, the Law Society of New South Wales announced that the mental health service provided to solicitors in New South Wales is going to be opened up to include a solicitor's spouse or partner. So that's the Solicitor Wellbeing Service that provides free counselling and mental health support to practitioners in New South Wales. And personally, I think this is fantastic. In terms of us, I think we all agree that solicitors need support, not only for mental health, but also in terms of our close personal relationships with those around us. And as someone who needed that support at one stage, I think this is an amazing initiative that will help solicitors who are undoubtedly a high-risk group when it comes to mental health and mental well-being. And I'm very interested in seeing where this will go, and I'm very interested in seeing what other support initiatives will come up as time goes on. But I think this is a fantastic step in the right direction. Building a stronger and more resilient profession is just so important, I think, especially with such high rates of burnout these days. And a lot of our clients, they think that we're just robots, that we have a magic wand to wave to fix all their problems. But no, we're actually human beings, and we have our own lives, we have our own emotions, and we have our own ups and downs as well. So this is just so incredibly valuable.
And as much as we like to think that we don't take on the impact that other people or our clients may have on us, it's difficult to do, and you can't help but sometimes absorb some of those feelings.
You are like a bit of a crumple zone for your client at sometimes, and I've seen many colleagues before just cry in their own offices because of the things they hear from their clients or the things they see in the material we look at every single day.
Yeah, and to have that support available for the people closest to those lawyers when the lawyer walks in the door and they talk about how they've been feeling after a potentially rough day, then to have support available to those people to speak to a trusted professional about how that has made them feel is so important.
Oh, absolutely. It's incredibly important, I think.
I read an article in the Law Institute of Victoria on their website actually, and there's new regulations that have been published under the Occupational Health and Safety Act. The rules came into effect, I believe, on the 1st of December, and it means that all employers have an obligation to eliminate risks arising from psychosocial hazards as much as is reasonably practical in the workplace, which I think is, again, an important step in the right direction. And in terms of the hazards, the psychosocial hazards that may arise, it could be from high or low job demands, low job control or poor role clarity, bullying and harassment in the workplace, poor organisational change management, remote or isolated work or exposure to traumatic events or distressing material. And those are listed on the Law Institute of Victoria website, which I've just read from there. That article also goes on to say that the legal profession can be particularly susceptible to those type of psychosocial hazards. And we could say, particularly in the area of family law.
Oh, absolutely.
As well.
Yeah, I definitely agree, and it's great that there is recognition that lawyers are high risk, at risk when it comes to these kinds of things, because, like that last point suggested, we are always exposed to traumatic events and distressing material, just on a day-to-day basis. So having that recognition is so valuable.
I agree.
The next update I want to quickly cover is that AUSTRAC has now published starter kits to assist firms in preparing for the AML legislation that's coming into effect. Both LEAP and InfoTrack are working to ensure firms stay on top and also stay compliant. So that's something to watch out for.
Excellent. Thank you. I think AML is on everyone's mind at the moment, ever since, for quite some time now. So I'm sure lawyers are pleased that AUSTRAC have now published those starter kits, and that there's some help for them to be able to make sure they're doing the right thing and following the right processes. I've also seen that most law societies are holding those educational events as well. I've seen it on a few of the state law society website, so it's probably worth checking out what your local law society is also doing in that space. This month is, I feel, a very exciting month with a lot of events coming up now that we're in February. The first one being the FCFCOA 50th anniversary dinner, which I believe is on the 19th of February evening in Melbourne. And we're very excited that we'll be flying down from Sydney to attend that event. And any listeners who will be attending that, it will be really nice to see you there.
Yeah, hopefully you're going to meet up with some of our listeners. I'm very excited to be there as well.
We also have the Family Law Intensive series kicking off. First one being in Sydney on the 21st of February. They will be running nationally, I think, in most states, but the first one is in Sydney, and I believe we will have a presence at most of those events, which we're excited to be at. We've also got the following week, and I'm pleased to say this, and I'm sure many of our listeners have heard about our conference that we are holding on the 27th of February at Pier 1 in Sydney. We have 200 attendees, and I'm not surprised that we have now got people on the wait list, because it's an excellent lineup of speakers. And that's it.
Yep,
for
that's what's
updates
up for this week.
for the week. For Law in Motion this week, we'll be talking about technology-facilitated abuse in family law matters, and I'll hand it over to Brendan to kickstart the discussion on that.
Absolutely. So these days it's just so easy to connect your devices to things that are ultimately designed and built for our convenience and benefit. So things like your Amazon Alexa, Google Home, video doorbells, pet cameras, cloud storage, and even the lights in the ceiling at your home. But just like that, someone can actually weaponize that technology, especially during the course of a separation. And look, I'm going to be the first one to put my hand up and actually admit to say that I'm guilty of thinking this. And perhaps we can all agree that we're all guilty of thinking, even if it's just for 1 second, that our client might be paranoid, overly sensitive, over-exaggerating, or just flat out crazy, because the concerns that they have just sound so outlandish. But they're actually often backed by real and lived experiences. And as family lawyers, we're tasked with the job of finding solutions to legal problems for our clients. But that doesn't mean we can't lend a helping hand to our clients in getting them started with protecting themselves in the digital world. But before we talk about that, I want to share some examples of technology being abused in matters I've had in the past. So some examples I have are things like using Find My Phone services to track a former partner's movements, transferring nominal amounts via online banking and attaching abusive messages to the descriptions, using AirTags or other GPS trackers to track their former partner, hiding them in things like handbags, under the floor mats in cars, between number plates in the car. I'm using smart home devices. I had a matter where the other party would actually make the lights turn red when they were within a certain distance from the home. Abusing cloud or shared family devices. In that same matter, the other party would delete the music my client was listening to in real time because he had access to the cloud storage and could see what files were being used. And speaking of shared family devices, I've had matters where parties leave their accounts logged in on the children's devices, for example, the iPad. iPad then travels with the child at changeover, and the other side then looks at the messages that my client was sending to their friends and family. And the last one, which I think is actually a pretty scary one, which was the case where the other party actually made an account for an online game, found the child that was playing that online game, befriended them, then started asking questions about what mum was doing, where mum was, what were the family's plans for the weekend, and really just trying to track the family's movements. And I can honestly probably go on and on and on about this, but these are just some of the examples where technology can and is being misused. And the last ones, I think, particularly are concerning because that's exposing the children directly to the conflict that should be kept really between the parents. And like I said, I could go on and on, but I'm interested in hearing your experience as well, Jenna.
It's devastating, isn't it, to hear all of those examples. And as you said, there's so many more that you can give. And I'm sure our listeners will have a multitude of other examples that they could share or that they're thinking about as you were talking about those ones that you've been involved in those cases and matters that you've had. I've had similar experiences to you. I know one of the apps, the Life 360 app, I've heard that being used for tracking as well, in addition to Find My Phone. And then with the Apple AirTags, I've also heard them being put in even the children's school bags. And then maybe the party didn't know where the children lived, and children goes home and it's in their school bag, and inadvertently they have led the perpetrator to
the new address, which previously wasn't disclosed until that started happening. It's just so easy, especially with how accessible this technology is. For $20, you can buy a pack of AirTags and stick that in places that they shouldn't really belong. And all of a sudden, you're now stalking, essentially, your former partner or perhaps the children when you really shouldn't be.
I know even with new tools that we've been building in-house, we think some of these tools, they collate so much information and they analyse that information as well and really put that information in a digestible way for lawyers to use. But we often think and we have to put safeguards in place for those matters where there are family violence, because if that information was to get in the wrong hands, then it can be quite unsafe for people.
Yeah, definitely.
So it is something that we're constantly thinking about.
Absolutely.
Having been exposed to it so much in our work, and we're so aware and hyper aware probably of the clients that go through it and the impact that has on people.
Yeah. And like you said, I'm very interested in hearing what our listeners have to say. So if you have a story, leave a comment, let us know, because we'd love to hear what your experiences are and how you dealt with that in your matters as well. But with those scary stories out of the way, let's take a bit more of a positive spin on this, and let's talk about ways that you can actually help your client if they tell you things like they feel like they're being watched, or their ex is listening to them, or he knows where I'm going all the time. I'm sure we've all heard these phrases from our clients before. So actually what some firms do is actually distribute a bit of a cyber safety checklist to their clients. And it can feature things like changing passwords, checking devices that are signed into an account and actually removing ones that they're not familiar with, making a brand new email account that they know that only they can access and their former partner cannot access. And of course, turning off location sharing. But there are some more complex or more extreme methods that can be used to protect clients, which often people aren't aware of, which is just things like using a new phone, which doesn't often come to mind automatically, but also ones that are like engaging a specialist service that can actually sweep phones and devices like laptops for malicious tracking software. Or even having them actually sweep your home, your car, your office for unwanted surveillance devices. They can actually go in there and see and scan for certain frequencies that could indicate that there are hidden cameras or hidden recording devices in there. And that last one, I actually personally wasn't even aware of that being an option until I attended a presentation at a CPD event a couple of years back. And that really just shows that whilst there's a lot of accessible surveillance equipment out there, there's also a wealth of counter surveillance options out there, which I'm not saying lawyers need to be fully aware of, but at least being able to tell their clients that options do exist. Because again, we don't have a magic wand. We can't solve every single problem they have, but we can at least point them in the right direction for ways that they can also tackle their problems that come up throughout the life of their matter. Even if it's not something we can solve directly, they can go to a supporting service to have that dealt with.
And have you had any involvement or have you looked into any of the services that are available? You mentioned that you heard.
Yeah, so I think it was a couple of years ago. I attended a presentation by someone from the Protective Group, and they're one of just many examples of services that can actually do what I just mentioned in terms of actually going and actually looking for hidden recording devices and hidden cameras and the like, and then they're able to give you essentially a comprehensive report on what they've found, if they've found anything malicious in a certain space.
I think it's very important for family lawyers to know that that is an option available, because I'm sure that there's a lot out there that didn't even know that that was a thing almost.
Yeah. I mean, that information is not readily available unless you actually are made aware of it. Then you start looking for it, because often we're so bogged down in case law and researching updates to things like the legislation and this and that we don't actually have the time or the mental capacity to look elsewhere for other sort of ancillary services or other things that might come up that might be useful for our clients. It's only really when you really sit down and take a deep dive into it do these things start popping up and become an option to you to give to your clients.
Yeah. Thanks, Brendan. I know that information that you've shared has been so useful for our listeners, because I've found it exceptionally useful hearing from you and about your experiences as well. For your questions answered this week, we will get into listener questions, and we received quite a few over the past week to answer today, which we're very grateful for. There was one question we received on the topic of maximising productivity in prompt drafting, which we feel does warrant a separate episode to deep dive into productivity in law firms generally, and we can talk about that aspect in that episode. I will mention now that we do have a podcast on the 12th of February at 4 p.m, which is Australian Eastern Daylight Time, on AI and everyday use for family lawyers, and it does address prompt drafting, so it could be worth tuning in to that as well if you're interested. To the first question, our listener Morgan has asked, what practical indicators do you look for when assessing whether a property matter is likely to settle early?
It's a great question. Thanks, Morgan. And I'd actually be interested in hearing what our listeners think. But from our perspective, if I actually had to condense that into a brief answer, I would say that the biggest indicator is where my client is on the grief cycle. As family lawyers, I think we're quite familiar with the grief cycle. And often we find that parties are more readily able to move on to a resolution and to move on with their lives if they're further along that grief cycle, if they're at that acceptance phase. And conversely, if they're still very angry and emotional, then they're perhaps not quite ready to move on with their lives, and it's going to take a little bit longer to settle the matter.
And it's often hard when you have one party who's well along the grief cycle, and then you have another party who isn't so
Yeah.
further along. And that is so common because you have someone often before a couple separates that has made up their mind that they've wanted to separate for many, many months, even many, many years beforehand. So they've been able to work through the grief cycle to a point when the other partner hasn't even
Well, they've been left
started.
behind in their own eyes. They're the one who was left behind, and they're then starting their grief cycle at that point when they've been made aware that separation is happening.
Our next question is from Pat. How do you manage burnout and emotional load in long-running or high conflict matters?
Thanks, Pat. That's another great question, and I think this one is very relevant to all family lawyers. Long-running and high conflict matters, I think they're always quite tricky to manage. Because it's just so easy to get emotionally attached and invested. It's not as transactional as, say, a simple divorce matter or a matter where parties come to you with an agreement and they just want it formalized in consent orders. And I know personally I've struggled with this in the past as well, which led to burnout. And Jenna, I know you're also very passionate about this as well. But tying it back to what I spoke about earlier in this episode, about using the resources available to you for support, whether it's friends, colleagues, or the solicitor's wellbeing service, because having a confidential chat with someone is just so powerful. Just like how our clients come to you just to really get things off their chest, it's helpful for us as well to do exactly the same. So having someone you can talk to, that's one of the things I would suggest.
Yeah, absolutely. And again, I think the topic of burnout, it's so common and everyone wants to hear how they can help manage that. So I think let's do a separate episode on that in due course as well, and we can deep dive a bit further into that and even talk about our own experiences as well.
Yeah, definitely. There's so much we can say about burnout.
And our final question for this week is from Suzanne. I'd like to clarify whether binding financial agreements are binding on a spouse's estate and whether they can be set aside after death.
That's a great question, Suzanne. So it sounds like there's two distinct halves to that question. The first being whether binding financial agreements are binding on a deceased party's estate, and the second being whether they can be set aside after the death of a party to the agreement. So to answer the first half, yes, binding financial agreements will continue to operate after the death of a party to an agreement. And that comes from Section 90H of the Family Law Act for married couples and Section 90 UK for de facto couples. As for the second half of that question, the answer is also yes. So binding financial agreements can be set aside after death, and the threshold for that is set out in Sections 90K and 90UM for married and de facto couples, respectively. So that will take into account things like fraud, material change in circumstances relating to the care of the children, and impracticability, just to name a few.
Great. Thank you, Brendan. And if any of our listeners have a question that you want answered, please send us an email at familylawpodcast@leap.com.au. You can also reach us on socials. We have TikTok and Instagram, so please message us on there. Our handles will be in our show notes. We've loved being in your ears this week. Please tune in for next week's episode. New episode drops every Monday.